Nehru was not in favor of introducing Hindu Code Bill as part of the first constitution itself. In protest to Nehru's refusal or resistance or reservation over Hindu Code Bill, Ambedkar resigned from the cabinet, went away. But since Hindu Code Bill was not happening, Ambedkar was agreeable that Muslim personal laws to be removed and uniform civil code to be brought about can be a part of the directive principles of state policy. The Sharia law or Muslim personal law was promulgated not by Allah but by the British. Dream of the makers of our constitution, they wanted a uniform civil code implemented for the whole country. That is Article 44. It was demanded again and again by the country's highest court, namely the Supreme Court of India. 4 or 5 judgments mandated that there should be a uniform civil code for all the people of this country. Friends, in 1978, a peculiar case came before the magistrate court in Indore in Madhya Pradesh. There was a guy called Muhammad Ahmad Khan. He was a lawyer. He married a lady called Shah Bano Begum. The marriage happened in 1932. This guy decided to divorce this lady in 1975. At that time, that lady, Shabano's age was 62 years. She had no source of income. The couple already had about 5 children. When this lawyer decided to abandon his wife at the advanced age of 62, 63 years, this wife sought some maintenance money. The guy refused. He said, "We are Muslims. Under this Muslim personal law, I'm not obligated to give you any maintenance money." This poor lady did not have any other means of survival. She approached the Indore Magistrate Court in 1978. The Magistrate Court looked into the whole case, whole matter, and decided in favor of this lady. But the judgment said that this guy, this lawyer, should pay rupees 25 per month as maintenance. The lady was naturally aggrieved. Number one, 25 rupees is not the kind of maintenance money that one would expect. Secondly, this guy was not so poor as to be given that kind of benefit of just paying 25 rupees to the wife that he was divorcing. So this lady approached the High Court, Indore bench. After 2 years of great contemplation, the High Court said, "All right, 25 rupees is very low. Please pay her 150 rupees per month as maintenance." Instead of agreeing to that judgment, this gentleman, Ahmad Khan, went to Supreme Court saying that I am not obliged under the Muslim personal law to pay, forget about 150, even a single penny to this lady. Because maybe under Hindu law, a divorcee has the right to get some maintenance, but under Muslim law, there is no such provision. We don't have to pay anything to the woman that we are divorcing. This case went on for 5 years in Supreme Court. At the end of 5 years, Supreme Court, imagine 5 years somebody going to Supreme Court, how much money he would have spent. This guy spent all that money but refused to pay 150 rupees as maintenance because his argument was, under my Muslim personal law, I don't have to pay anything. The Supreme Court, after great deliberation again after 5 years, decided that 150 is too meager, pay 500 rupees. That is called the famous Shabano judgment. Many of us know about it. The tragedy of Shabano's judgment was that in the first place, it was how should we put it, insensitive a judgment that only 500 rupees as maintenance. But what was worse was this issue was taken up by All India Muslim Personal Law Board. They made a major political campaign out of it, reached out to the then Prime Minister and the then government, and they managed to get a law passed in the Parliament in 1986, affirming that Muslim personal law would prevail, meaning this husband is not obligated to pay any maintenance, But since the court has mandated 500 rupees to be paid as maintenance to this poor lady Shabano, the state will pay. The guy won't pay. You all have to pay. Because state means what? We all pay the taxes. From that state gets money. So that guy will say triple talaq and give up that lady, end the marriage, and we all compensate the woman. This is called the famous Shabano case of 1980s, which became a big controversy. I'm not going very much into it. But in that 1985 judgment, which awarded, little extra money to this poor lady, from 150, it was made to 500. The then Chief Justice was Y.V. Chandrachud, father of the present Chief Justice of India. Y.V. Chandrachud made a fervent appeal that time has come for us to end this business of separate laws, separate personal laws. We should promulgate a uniform civil code. He asked the government to consider that. It's another matter that Rajiv Gandhi was the Prime Minister. Rajiv Gandhi's government, instead of listening to the Supreme Court, listened to the All India Muslim Personal Law Board and reaffirmed the validity of Muslim personal law. Then in 1995, another similar case came before the court. This also reached up to Supreme Court. In this particular matter, one guy he was a married guy, wanted to have another woman as his wife. He simply got converted to Islam and married, citing the Shariat as our Muslim personal law as a validation for his act of having more than one wife, which we call in English as polygamy. Technically, under Sharia it is allowed. Under Muslim personal law it is allowed. So Supreme Court once again told the government that, don't consider Muslim personal law as a personal matter of Muslims alone. It can affect anybody. In this case, it is affecting a Hindu. A Hindu husband and wife, they are affected because this guy decided to convert. There is a very famous case in Kerala where a Muslim couple married under the Muslim law, Muslim personal law, nikah they call it, which is sanctified by a Qaji, by a Maulvi. After about 15 years of their marriage, they decided to marry again under Hindu law. The reason was they had 3 daughters. Under the Muslim personal law, the property of the parents, only half of it can go to the daughters, remaining half will go to the next male successor. In this case, because there was no son in that family, this would go to the brother of that person. So in order to secure their property and give it whole property to their daughters, they had to remarry under Hindu Act. That is why Supreme Court in 1995 said, don't consider Muslim personal law as Muslim related law. It can affect the entire society. We didn't listen. In 2003, in another matter, Justice Khare, who was the Chief Justice of Supreme Court, again asked the government, come on, time has come. How long can you postpone it? Do it. We don't do it. In 2015, the 4th time, Supreme Court once again reminded the government, but probably time has come for you to consider it. In 2021, Saira Bano, one Muslim lady, went to Supreme Court again, asked the Supreme Court, why don't you, relieve us of our sufferings, this polygamy, this triple talaq, why don't you relieve us? Supreme Court again suggested to government, why not it be done away with? At least 5 times, India's Supreme Court has asked the government that it should go. In 2015, 2 women wrote a letter to our Prime Minister, Noorjahan Safia Niaz, Jakia Soman. These 2 women, 2 Muslim women, they had an organization called Bharatiya Muslim Mahila Andolan, nothing to do with RSS BJP. It's an independent organization of the Muslim women. They wrote a letter to Honorable Prime Minister Narendra Modi ji. In that they demanded that from Shabano in 1985 till date, Muslim women have never been heard in matters concerning their lives, thanks to the politics of our country. You are not listening to women, Muslim women. Muslim women, certain orthodox and patriarchal males have stonewalled any attempt towards reform in Muslim personal law. In the process, Muslim women have been denied their Quranic rights as well as their rights as equal Indian citizens. Almost all Muslim countries, they went on and on. They actually gave some data to our Prime Minister. They said they conducted a survey among the Muslim women, and as per their survey, an overwhelming 92.1% women wanted a total ban on triple talaq, oral or written. Talaq should be banned. 91%. 91.7% opposed polygamy, multiple wives. 83.3 women said that codification of Muslim law will help Muslim women get justice. Muslim women demanded it. In fact, these two women of the Bharatiya Muslim Mahila Andolan, they prepared actually a draft. What happened in the last 8 years was some of the issues that these women flagged in 2015 were taken up by present government of Prime Minister Modi ji. Number one, the practice of triple talaq has been ended in this country. There is some legal formality remaining. Once that is also done, this process of triple talaq is no longer available to the Muslim males in our country. It's a great justice being delivered to Muslim women. It's not a religious question, because in the entire Muslim world, including our neighbors, Bangladesh and Pakistan, triple talaq is not there. Remember, they are Islamic countries. They follow Sharia law, but they legally prohibited triple talaq as the means of divorce. Even if you promulgate triple talaq, it has to be ratified by a legal agency. You can't simply say triple talaq. It used to be so very inhuman that he would send an SMS or a WhatsApp, talaq, 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 and you are gone. Or in the sleep, in the dream, by mistake, people do dream talking, like dream walking. In the dream, he says by mistake, talaq, talaq, talaq. The lady next to him is gone, his wife. This used to be the practice. So, that practice is not validated in Islamic countries like Turkey, Tunisia, Egypt, even Syria, Pakistan, Bangladesh. It's not valid. So our government of Modi ji said, okay, in India also, we will not allow that simple talaq to end the marriage. So there is a legal system being put in place. Similarly, these women of Bharatiya Muslim Mahila Andolan demanded that, Hindu law prohibits marriage below 18 years of age for girls. But there is no such restriction in the Muslim personal law. As a result, a girl can be married off at the age of 12. By the time that girl becomes 18, she would be the mother of 2 or 3 children. And early age pregnancies lead to so many complications of women. They die, they suffer, they struggle for the whole life. The government declared 21 years as the minimum marriageable age for everybody across the board, including Muslim women. This is a humanitarian gesture. This is about gender justice. This is about equality. In that same spirit, today, if Prime Minister says that why not we have one uniform civil code for the whole country, where is any controversy in this? As I said, if a Muslim earns a lot of money, he has a lot of money, suppose, then he wants to start a trust to run this college. This college is run by women. If there is a Muslim gentleman, he wants to start a trust. Do you know that under Muslim personal law, he has no authority or power to start a trust? He cannot start a trust. All that money he wants to contribute for the development of any social activity has to be given to Waqf board. Only Waqf is allowed. You can't have individual charity. Is it justified? So the whole effort is more about humanity, more about equality, more about gender justice, less about religion. Even assuming there is a religion component of it, If it is wrong, it should go. Do you know that among the Hindus, we used to have many types of different laws, like we used to have Mitakshara law in Eastern India. Some people used to follow different kinds of Hindu codes. But in 1954, 55, 56, government of Nehru decided that all these laws should be brought under a codified law. That's how Hindu Code Bill came into existence. Some people had objections to it also. There used to be a party called Ramarajya Parishad those days. Ramarajya Parishad was against certain reforms under Hindu Code Bill. But the wider Hindu society has accepted it. Hindu Code Bill included Hindus, Buddhists, Jains and Sikhs, and created a common civil code for all these people who constitute 80-83% of Indians. Now tell me, 80-83% of Indians have one common code. Is it justified that 13, 14%, 15% demand that our civil code should be separate? Why should matters like marriage, divorce, succession, adoption be different? My father was an advocate. We used to get an old client who was a Muslim farmer. He had 3 sons and 1 daughter, or 2 sons and 1 daughter, I don't remember exactly. He used to argue with my father that I want to divide my property equally among my 3 children. My father used to explain to him that you can't do. You can only give a little amount of it to your daughter, but the rest of it has to be equally divided between your sons. But he would say, but you give same amount of share to your children. Why can't I give? My father used to tell him, but you are guided by a separate law. But why should he be guided by a separate law? Why not it be equal? Friends, this was to be actually a common law for the whole country. When constitution was being made, the original proposal was to have only one civil law for the whole country. But there was a minority subcommittee in the Constituent Assembly. The minority subcommittee had raised objection to it. They said that we have our personal laws, we want to be guided by the personal laws. You can't impose your laws on us. Unfortunately, the then leadership, Nehru and others, were of the view that, okay, we should not impose anything on them. So they decided that let us keep it under the directive principles of state policy. What are directive principles of state policy? They are the objectives of the government after independence. When an independent government is formed, that government would strive to achieve them. They are called directive principles. They are not for the citizens. They are for the government to achieve. They are called directive principles of state policy. State should endeavor to achieve them. One of them was Article 44, under which this Uniform Civil Code came. Even then, there was a big objection from Minority Committee, Constituent Assembly's Minority Affairs Committee. They objected, saying that no, don't call it uniform. You call it optional Uniform Civil Code. It's an oxymoron. You know, those who know English well will tell that either it has to be optional or it has to be uniform. It cannot be optional uniform. Uniform means for everybody. Optional means for those who want. So those two cannot go. So Ambedkar stood up and said, Baba, this won't work. I can't give that kind of a definition to this act. Okay? I leave it to the independent government to implement it in future, because maybe today you are not ready, but maybe 10 years hence, 15 years hence, you will be ready. But those days, Ambedkar had another reason also for doing that. He wanted Hindu Code Bill also to become a part of the very constitution itself. He wanted a reformed code, social code civil code for Hindus. Nehru said no. Nehru's view was, right now we are in the midst of so much of turmoil. We just came out of partition, Hindus, Muslims, these religious tensions. I don't want this tamasha now. Maybe Nehru had some other views about it. We can't say anything. But Nehru was not in favor of introducing Hindu Code Bill as part of the first constitution itself. In protest to Nehru's, refusal or resistance or reservation over Hindu Code Bill, Ambedkar resigned from the Congress, resigned from the cabinet, went away. But since Hindu Code Bill was not happening, Ambedkar was agreeable that Muslim personal laws to be removed and uniform civil code to be brought about can be a part of the directive principles of state policy. Remember, in 1950, Hindus also had their personal laws. When our constitution came into being, just as Muslims had personal laws, Hindus also had personal laws. In 1954, when the Nehru government decided to implement a uniform civil code for all Hindus, which is called Hindu Code Bill, right? Hindu Code Bill was a uniform code for all Hindus who were having different personal laws, should be codified, brought under one bill. Why did he not bring Muslims also under that and Christians also under that? Again, Nehru explanation in 1954 was, no, Muslims are not ready yet. So let me first do it for Hindus. We will do it later for Muslims. So we had an opportunity to bring a uniform code for the whole country, a civil code for the whole country in 1954. Hindus, except for a few groups here and there, broadly accepted that reform. We today have a common code where the marriage is fixed. You can have only one wife. We used to have polygamy among Hindus also. And there is a procedure for divorce. You can't just simply divorce just like that. It is a legal procedure. There is a definite way of succession that has been improved in 1956 when Hindu Succession Act came. It clearly stated that women in the house will get equal share. Look at the Hindu progressive attitude. We did not oppose. We said we welcome it. In our household, our girls have equal rights as boys. We accepted it. Hindu Code Bill included Jains, Buddhists and Sikhs. It's another matter. Subsequently, in 1970s, Buddhists were declared as minority. In 1991, Sikhs were declared as minority. In 2014, Jains were declared as minority. But original Article 25 includes all of them under the definition Hindu, and Hindu Code Bill is applicable to all of them. We had a civil code which is applicable to all except Muslims, Christians and Parsis. Parsis are a very small minority. And as far as Christians are concerned, they only have one act which talks about succession, that is inheritance. And that they have a 1925 vintage act. That can be amended. Many Christians don't follow that nowadays. Other than that, in any case, in Christianity, especially if you are a Catholic Christian, divorce is a sin. You can't divorce. Once married, married for life. So they don't have that problem. They don't have any system of talaq. So largely they follow the country's civil code. But there is this peculiar challenge with the Muslim personal law. Now the argument of Mr. Sultan Salahuddin Owaisi or the Muslim Personal Law Board is that it is a divine law. The law was given by Allah, so you can't change it. Do you know? The Sharia law or Muslim personal law was promulgated not by Allah but by the British. It was in 1937 that what is called as Anglo-Muslim Act, Sharia Act, was promulgated by the British government in 1937. Before 1937, anyway, we did not have one government in the whole country. British were controlling parts of India, but there were independent kingdoms and all. In most of the kingdoms, Muslims were following the existing Hindu law. Never was there any objection. In fact, in 1891, there was a census conducted for the first time by the British. And they wanted to determine the religion of the citizens. Those days, Bengal used to be the biggest province in India with almost 8 crore population. India's population was around 30 crores, out of which 8 crores used to live in one province called Bengal. The Census Commissioner of Bengal recorded that it is very difficult to differentiate between Hindus and Muslims because the Muslims also participate in Holi, Diwali, Durga Puja. They also perform all this Chhat Puja and all these things. So it is very difficult to determine who is a Hindu and who is a Muslim. Same was the situation in Maharashtra in 1911 census. They said that, many rituals are common to everybody. This whole separation, we are separate, was actually a product of Muslim League thinking. It was Jinnah's jinni that led to this kind of separatist attitude among the Muslims in this country. So it was nothing to do with the Islamic religious, doctrines or whatever. I told you, in the entire Islamic world, this kind of personal laws are not sanctioned, they are not allowed. So this argument that it is a divine law, you cannot tamper with it, is utterly baseless. Having said it, this uniform civil code, which Honorable Prime Minister has talked about, is something on which the Law Commission of India is working. We have not yet seen any draft of it. We are already jumping. It's against Muslims, against Islam. What will happen to our identity? Nothing will happen. There is no threat to any religion in this country. This law will bring some kind of uniformity in our social behavior. It's not going to affect your religion. So the propaganda that is going on, even before there was any draft law before us, is just either a political ploy or a communal rhetoric. Friends, the Uniform Civil Code was the dream of the makers of our Constitution. They wanted a uniform civil code implemented for the whole country. That is Article 44. It was demanded again and again by the country's highest court, namely the Supreme Court of India. 4 or 5 judgments mandated that there should be a uniform civil code for all the people of this country. We already have a uniform code for 82% of Indians. We need to have it for 100% of Indians. And number 3, most importantly, the Muslims themselves, especially the women of Muslim community, in large numbers means more than 90% of the Muslim women today want freedom from this so-called unjust, anti-woman Muslim personal law. So in its own wisdom, the government will take a proper view after consultation with all the stakeholders. When I say stakeholders, they include Muslim Personal Law Board also, AMPLAB also, Muslim Personal Law Board also. Everybody will be consulted. But the bottom line is, what the makers of India's constitution visualized in the form of Article 44 of India's constitution, namely, the state shall endeavor to bring a uniform civil code for all the citizens of India, must be realized sooner than later. Thank you.